Welcome everyone to today's webinar, Your Rights of Appeal, Understanding the National Appeals Division when Applying for Loans and Debt Servicing. This webinar is the final installment of our Credit and FSA Program webinar series that includes sessions focused on a variety of Farm Service Agency program topics including business planning, credit repair, financial and marketing risks, youth loans, microloans, and fractionated land loans, and understanding your rights of appeal. If you look at the handout section of your control panel, you'll find the slideshow being presented today that you can download and keep for later reference. I also invite you to visit our website at indigenousfoodandag.com, where you'll find more information about this series and downloadable copies of the presentations. We will also post and archive videos of each webinar to that webpage. All attendees will be muted during the presentation. Attendees should use their control panel to raise their hands, or you can submit questions using the questions dialog box. Today's presenter will answer questions at the end of the presentation. This series is possible with support from the USDA Farm Service Agency and the University of Arkansas School of Law Indigenous Food and Agriculture Initiative, who have joined to offer this important series of webinar trainings. I'd like to introduce today's presenter, Toni Stanger. Toni is the owner of a consulting firm and the founder of IndianCountryGrants.com. After graduating law school, she worked for the United States Department of Agriculture, Office of the Assistant Secretary for Civil Rights in Washington, D.C. During her time in civil rights, she led the office in reviewing thousands of outstanding claims, as well as the settlement of the Keep-Seagle opt-outs, resulting in the protection of more than 380,000 acres of tribal land from foreclosure. Toni moved from civil rights to the USDA Office of the Secretary, where she represented the department in working with the United States Forest Service on improving sacred sites policies. She now works with tribes in lending, business, and infrastructure development, code writing, and agricultural development. And with that, Toni, the presentation is yours.
Til hast is Squinshuden. Hello, everyone. My name is Sutitqua Water Runs Downhill. I'm a citizen of the Colville Confederated Tribes, and I'd like to thank you for joining us today. And with that, we'll go to our first slide. So today's session is about the National Appeals Division. The National Appeals Division is housed within the Office of the Secretary at the Department of Agriculture. Within the Office of the Secretary, NAD is an independent office. Through their independence, they represent various offices and agencies within the umbrella of the Department of Agriculture. Those include the Farm Service Agency, the Risk Management Agency, the National Resource Conservation Service, Rural Development, and within Rural Development, the Rural Housing Service, Rural Business Cooperative Service, and the Rural Utilities Service. NAD's basic mission is to conduct evidentiary administrative appeal hearings and reviews arising from program operations of assigned agencies. NAD provides a means through which participants can receive timely, face-to-face fairness hearings for disputes arising from their respective farm program and rural development requests. Filing an appeal with NAD gives the appellant a chance to explain why they do not agree with an agency decision. Accordingly, the appellant presents their case and any evidence in person or by telephone to administrative judge, hearing officer. So I will provide resources towards the end of this presentation, and in those resources you'll find a guidebook that was developed in 2008. In the 2008 guidebook, they use the term hearing officer Now, since 2012, they have started transitioning over to administrative judge. But where you see administrative judge, or ALJ, or AJ, and hearing officer, it is essentially the same person. This is the judge, the presiding officer over your appeal. So the administrative hearing or administrative judge or hearing officer determines what happened, reviews all the evidence, and will make the final administrative decision, and that is your appeal. So NAD is limited, and they have various things that they don't do. One of those is that they don't hear certain types of cases. NAD has no jurisdiction over the appropriateness of agency regulations and does not adjudicate discrimination complaints or equal employment disputes. NAD only decides whether an agency complied with applicable laws and regulations in rendering adverse decisions under appeal. NAD does not review decisions where alternate appeal proceedings are established. For example, appeals under the Packards and Stockyards Act. Also, NAD does not review Board of Contracts appeals and tenant grievances under Rural Housing Service. And NAD has no enforcement authority. Implementation of a final determination are the responsibility of the head of the agency involved. NAD's final determinations are reviewable and enforceable in federal courts. There are other forms of resolution for issues that you may have. Those include mediation and alternative dispute resolution. You have the right, an appellant has may request mediation or alternative dispute resolution, abbreviation ADR, after the notification of appeal rights. But before requesting the appeal, the 30-day period for rendering an appeal stops running when the mediation request is made. If mediation concludes unsuccessfully, the appellant has the balance of the 30 days within which to file an appeal request, if desired. Mediation requests after appeal request. A request for mediation or ADR may be requested after you have already requested an appeal. In such cases, the participant will be deemed to have waived their right to a hearing within 45 days of NAD's receipt of the request for appeal. If mediation or ADR is unsuccessful, the participant has the right to a hearing within 45 days of the conclusion of the mediation or ADR as specified in 7 CFR Section 11.5. Here are the NAD field offices and the contact information for the national office as well. You'll also find the email address. When you're filing a NAD request, you can utilize both your regional office and your national office. Also realize that in certain disputes, you will also need to contact your county committee, your FSA county committee, because that is part of the administrative process, is exhausting all of those remedies. And in certain instances, the county committee has the authority to make determinations on applicants. So they would have you would have to go through the county committee before you go onto an appeal within your regional office or a director review within the headquarters. Next slide. The appeal. An appeal request should include the following. The appeal must be filed with NAD within 30 days of receipt of the adverse decision. It must be personally signed. It should include a copy of the adverse decision. It should include an explanation of why the participant believes the adverse decision is not correct. Once an appeal is filed, there can be no ex parte contact. There can be no communication about the merits of a case between a NAD employee and any person outside of NAD with an interest in a case without the opportunity for other parties to participate. If ex parte communication occurs that is knowingly made or caused to be made by a party, the hearing officer or the director may, to the extent consistent with the interests of justice and the policy of the underlying program, require the party to show cause why the party's claim or the appeal should not be dismissed, denied, disregarded, or otherwise adversely affected. Who can appeal to NAD? Who is a participant? A participant is an individual or entity that has applied for a payment, loan guarantee, or other benefit in accordance with any program of a specified agency. A participant also is anyone whose right to participate in or to receive any such benefit is adversely affected by a decision of an agency. Also note other parties, such as third parties or interested parties. Third parties and interested parties can both participate in an appeal, but only third parties can become appellants. Interested parties do not become appellants, and I will discuss that later on slide 14. An appellant has a right to a hearing within 45 days of a receipt of a perfected appeal request. Who can appeal to NAD continued? Partnerships, corporations, and other entities. An appeal request from a partnership may be signed by any partner. An appeal from a corporation or entity may be signed by an officer of the corporation or entity. NAD may require proof that the signer is authorized to represent the entity. This is of particular interest to individuals that are part of trust land, maybe allotments, when you need to get from other individuals with an interest in the property you're utilizing for farming or ranching a majority share document that states that you have the interest to operate and request services for that property, even though it is a fractionated share, or you are heir on either some type of trust or restricted property or an allotment. So power of attorney, the fact that a person is represented by another party does not change the obligation that a participant must personally sign the request for a hearing. In addition, an attorney must present NAD an authorized representative declaration. The declaration must also include an attachment with the representative's written authorization. If an attorney presents themselves without the attachment, the request will not be considered perfected. It has to be signed by the participant. What is an adverse decision? Participants in or applicants for a program administered by USDA agencies designated by law and regulations may appeal adverse decisions by those agencies. An applicant or a participant may be an individual or an entity, corporation, partnership, joint venture. An adverse decision is a decision by an officer, employee, a committee of an agency that is adverse to the participant. This includes the denial of equitable relief by an agency or the failure of an agency to issue a decision or act on the request or right of a participant within the time frame specified by law or regulation or within a reasonable time, if there is no time frame in law or regulation. So if you do not receive a letter stating an adverse decision, instead it could be an issue of delayed response to a request that you've made, this still gives you the authority to file an appeal. as long as it's within a reasonable time frame. Your appeal rights. You have a right to appeal this. This is the notice that you receive normally when you get an adverse decision, or the disclaimer at the bottom of a document that you may receive. You have the right to appeal this decision in accordance with Title VII of the Code of Federal Regulations, Part 11. In an appeal, you must prove the decision is erroneous. If you wish to appeal this decision, your written request for appeal must be submitted no later than 30 days from the date of receipt of this letter and must be personally signed by you. Send the request to the National Appeals Division. I've included those addresses on the previous slide. Include a copy of this letter as a statement explaining why you think the decision is erroneous. A copy of your appeal request and attachment should be sent to this office. The request should include your name, address, and phone number. As an appellant has the right, if he or she chooses, to appear in person before an ad hearing officer. Hearings may also be conducted by telephone. An appellant may also choose to proceed with a review of the written record. In an in-person hearing, the appellant has the right to request that meeting take place in their state of residence or a location that is convenient to the appellant. NAD also supports the spirit of the Americans with Disabilities Act. Upon receipt of a timely notice of the need for accommodations, NAD will make an effort to provide reasonable accommodations for participants, including appellants, representatives, and witnesses. All accommodations include the provisions that at NAD's expense. These also examples include a sign language interpreter for the hearing impaired, large print Braille, or in certain instances, a tribal interpreter. A participant may file an appeal of an adverse decision, and all requests must be made, again, personally signed, within the prescribed time frame, usually 30 days. Where there is no adverse decision, the appeal must be requested no later than 30 days from the time the participant knew or reasonably should have known that the agency had not acted within the time frame specified by regulations, or where no time frame is specified, no later than 30 days after the participant reasonably should have known of the agency's failure to act. The regional assistant director and the hearing officer are responsible for determining whether the appeal is timely. Filing an appeal continued. An appeal is perfected when it is received within the appropriate time frame, generally 30 days. It is personally signed by the appellant, and a copy of the adverse decision being appealed is supplied. If the appeal is based on the agency's failure to act, the appellant must identify the request upon which the agency has failed to act. An appellant has a statutory right to hearing. Time is determined from the date of the receipt by an appellant of the adverse decision. If the date is not known or is not reported by the appellant, it's normally 7 days from the date mailed. The right to request an appeal belongs to an appellant. Once a request for appeal is accepted, only an appellant may withdraw it. However, an agency may rescind its adverse decision. There are several reasons why an appeal may be dismissed: bankruptcy, lack of jurisdiction, late filed appeal request, mediation and alternative dispute resolution, and also discrimination complaints. There can also be a suspension of an appeal by the regional assistant director or on his own initiative or upon the request of the hearing officer. Suspension will be granted for good cause. A review of suspension will take place every 60 days. Appellants requesting suspension waive the right to the hearing within 45 days of NAD's receipt of the adverse decision. Note that brief delays may require suspension, but can also be granted a waiver. Filing an appeal continued. An appeal is perfected when it was received within the appropriate time. Other parties. When an appeal is accepted by NAD, the parties become an appellant. Third parties may also participate in the appeal. Third parties may include a variety of individuals or entities, such as a tenant in an appeal involving a payment shared with the landlord, or a recipient of a portion of a payment shared by multiple parties. Third parties that have notice of the appeal are bound by the appeal determination. Interested parties whose rights are not being adjudicated but may be affected by the appeal determination of an appellant may participate in an appeal. Notice will be provided when the appeal is requested. They are not entitled to a 14-day hearing notice, and the appeal will not be discontinued pending notification of interested parties. Interested parties not identified in the case, they do not have the same authority as a third party. Interested parties may not request director review or reconsideration, but both interested parties and third parties will receive copies of final determinations. The role of the hearing officer or administrative judge. Again, the term hearing officer is from the guidebook, and the guidebook is still active, and you can find it on the website. But in the field, you'll hear the term administrative judge. In 2012, the NAD moved towards utilizing more attorneys or lawyers with adjudicative experience to process NAD hearings. Formally, hearing officers could be lay employees, program specialists with experience within various agencies or offices, but they did not require them to be attorneys. Now they are required to be attorneys, preferably attorneys with adjudicative experience, but again, it's the same term, hearing officer, administrative judge. We have used the term hearing officer because that's what's in the guidebook, and if you're looking to prepare an appeal, you'll probably utilize the guidebook. A hearing officer is a NAD employee who has been appointed by the director to hear and decide cases. The hearing officer issues an appeal determination that rules whether or not the agency's adverse decision was erroneous. The hearing officer shall be fair and impartial, avoid bias based on race, color, national origin, sex, religion, age, disability, political beliefs, sexual orientation, marital status, family status, and exhibit no bias in favor of any party, and must prevent personal or political beliefs from influencing the outcome of a case. The hearing officer will gather facts provided verification of timeliness of appellants, and gather any other pertinent information, and finally establish a complete record. A hearing officer cannot grant equitable relief. If the appellant seeks equitable relief, the hearing officer should make findings of fact on which the director may determine whether to grant the relief. The hearing officer shall conduct a hearing that affords all participants their rights, prepare a sound, well-supported determination, and limit the determination to the extent of their authority. Once an appeal is processed within a regional office, the administrative law judge or hearing officer will do the following: receive the case record for the regional office, schedule the pre-hearing and hearing, and holds pre-hearing and hearing with the parties to the case. The pre-hearing teleconference is anticipated in all appeals. An appellant has the right to a hearing within 45 days of NAD's receipt of a perfected appeal request. The pre-hearing teleconference. Again, a pre-hearing teleconference is anticipated in each appeal. Assignments of an appeal to a hearing officer is at the sole discretion of the director or his or her designee. Assignments of appeals may be based on location of the appellant and the agency office, availability of hearing sites, security concerns, hearing officer's caseload, hearing officer's availability, conflict of interest, and other appropriate factors. Pre-hearing conferences are anticipated in all appeals. The pre-hearing conference provides an opportunity to resolve the matter or otherwise narrow the issues involved. The pre-hearing conference should be scheduled sufficiently early to provide for a hearing within 45 days of the receipt of a request for review, while allowing the required 14-day notice of a hearing. If a party does not participate in the pre-hearing conference, the proceedings may continue with a discussion of procedural matters related to the appeal. Another pre-hearing conference may also be scheduled, if requested, or at the discretion of the administrative judge. Suspension of appeals. Appeals may be suspended before the completion of the hearing. Hearing officers do not have the authority to suspend cases. The regional assistant director may suspend a case on his or her own initiative or upon request of a hearing officer. The basis for a suspension shall be documented in the case record. Discrimination complaints. If an appellant files a discrimination complaint with USDA Office of Civil Rights concerning matters in an appeal, NAD usually will not suspend the case. However, a regional assistant director may suspend the appeal if an appellant is part of an active class action civil rights suit. NAD usually will not suspend a case. However, a regional assistant director may suspend such an appeal. During the Keep Siegel litigation and similar class actions, these types of cases were, many of them were suspended. That allowed for appellants to remain within their 30 days or prescribed time frame for filing these complaints, so that if they chose to, they could then pursue their issues through NAD after the class action was settled. Other reasons for suspension include mediation and ADR, litigation, illness or unexpected or temporarily unavailable parties that are essential witnesses. Request a record of review. An appellant may request a record review instead of a hearing at any time before the hearing. In a record review, the hearing officer examines the agency record and other information and arguments submitted by the parties and issues a determination. In most cases, the administrative judge has 45 days from the receipt of a request for a record review to issue a determination. Parties may include information such as affidavits and declarations, All information shall be provided to the other party. The parties may comment on each other's submissions. Any testimony should be in an affidavit or statement, sworn under penalty of perjury. The hearing officer may ask for clarification or additional information. In most cases, the hearing officer has 45 days from the receipt of the request for the record review to issue a determination. Preparing for the hearing. The burden of proof. The appellant has the burden of proving that the agency's adverse decision was erroneous by preponderance of evidence. That is, that the appellant shall prove that the agency erred in finding the facts or in applying its regulations. When a party has the burden of proof, the party must present through testimony and exhibits enough evidence to support the claim. The amount of evidence required varies from claim to claim. Appellant participants will identify witnesses, gather documents, and organize his or her presentation. Copies of all submissions must be provided to the hearing officer, the agency, other appellants. The appellant must inform the regional office and/or the hearing officer of any third parties of whom they are aware. Regional office personnel shall verify the timeliness of the appeal requests and acceptability of the signature and jurisdiction, notify appellant and agency decision makers of acceptance of the appeal, assign the case to a hearing officer, and record the assignment in the appeal database. Hearing officer will determine if there could be a real or perceived conflict of interest, schedule a pre-hearing conference if appropriate, and issue a notice thereof to allow all parties and the hearing officer an opportunity to review the agency record. A pre-hearing conference will be scheduled. The hearing. Hearings may be held in person or by telephone. Appellants may request themselves. These individuals are known as pro se, may represent themselves. These appellants are known as pro se appellants. Appellants may also have representatives at their own expense who may be either lawyers, friends, family, accountants, farm managers, or advocacy groups. The agency representative will provide the appellant, the hearing officer, and any third party a copy of the agency record. The agency may be represented by an agency employee, which, as I discussed earlier, is now an attorney, or occasionally by a lawyer from the Office of General Counsel, which is very unique. It doesn't happen very often. Normally, it is an AJ that is hired to represent NAD specifically. Witnesses are entitled and can provide relevant or oral documentary evidence. This should be limited to factual information within their personal experience that is relevant and material to issues on appeal. The hearing officer may limit the number of witnesses. Parties to the appeal have the right to question all witnesses. Joint hearings can occur when it is in regard to the same appellant with the same adverse decision. The hearing officer will prepare for the pre-conference hearing by studying the documents submitted by all parties, reviewing the regulations, and ensuring that the needed administrative arrangements, such as translators, are prescribed. The hearing continued. The hearing officer expects the appellant to submit a statement why he or she believes the decision is wrong. In addition, they may stipulate deadlines for submissions of other documents, as well as a list of anticipated witnesses and a brief summary of their testimony. Generally, the same deadlines will apply to both appellant and the agency. Parties should provide copies of documents they intend to introduce into evidence to all parties. The hearing officer may exercise liberal discretion with respect to pro se applicants. All exhibits should be labeled before the hearing. Example, page 1 of Appellant Exhibit B, page 1 of. Each page must be numbered in the lower right corner in sequential order. A cover memoranda must also be numbered. There is a style guide that is also part of the resources at the end of this presentation and available on NAD's website. And the style guide will include examples of how to draft your appeal request and documents for a hearing. Discovery is a method by which parties obtain evidence from one another. This may include depositions, testimony, interrogatories, written questions and answers, and document requests. The hearing continued. Each party can rebut the other's case. Rebuttal involves presenting evidence or arguments to disprove or discredit an argument. The hearing officer may ask questions to clarify points. These should be neutral and objective. However, in pro se applicants, a judge will normally give leeway to those that are representing themselves. In these instances, however, a judge should not present themselves as advocating for the pro se applicant, but they can dive deeper into various questions or witnesses in order to assist those representing themselves. Cross-examination of witnesses is permissible. The hearing officer shall establish deadlines for any further submissions. Recess may be administered during this time. And all of these hearings are recorded. During a recess, the recordings will stop. The hearing officer shall adjourn the completed hearing. A failure to appear, if an expected party and our rep does not appear at the pre-hearing or hearing, the hearing officer should wait a reasonable period of time. The hearing officer may also cancel the hearing. Important dates and timelines. Participants must file an appeal within 30 days of the receipt of their adverse decision or failure of an agency to act. Parties must have a 14-day notice of the hearing unless parties waive their right to such notice. A neutral site will be used. The hearing should not be scheduled late in the day. When multi-day hearings are anticipated, parties should be provided notice. The appellant has the right to a hearing within 45 days of the appeal request, but may waive that right if they choose to. A hearing officer should reschedule a hearing only once, no more than 30 days from the original hearing date. If beyond 75 days, it must be approved by the regional assistant director. A request for a witness subpoena must be submitted at least 14 days before the scheduled date of the hearing. A hearing officer determines that the issuance of a subpoena, if it is required, he or she shall forward a completed subpoena checklist through the regional assistant director to the director. The requested party is responsible for travel and reasonable costs and fees of the server and the subpoenaed witness. However, USDA pays the costs associated with the appearance of a department employee whose role as a witness is related to his or her office duties, regardless of which party requests the subpoena. Failure to pay the fees may require a striking down of evidence. The DOJ, Department of Justice, may be involved when there is a failure to comply with a subpoena. The appeal determination. The hearing officer shall close the proceedings, establish deadlines for any further submissions, note the date the hearing record will close, and explain when a determination will be issued. At the closing of a hearing, the hearing officer will not indicate what decision will be issued or discuss the pervasiveness of any evidence or testimony. Evidence that was unavailable at the hearing, such as parties' responses to new issues or evidence presented during the hearing, may be submitted after the hearing. Generally, the record may be kept open for no more than 10 days. Extensions of more than 20 days are discouraged. The appeal determination continued. An appeal determination is based on the case record, laws applicable to the matters at issue, applicable regulations published in the Federal Register, generally applicable interpretations of regulations and law which may include but are not limited to court decisions interpreting a particular program provision, a handbook or other official document interpreting an agency's regulation. The appeal determination states whether or not the adverse decision is erroneous. It specifies the findings of fact and conclusions based on those findings as they relate to applicable laws and regulations. Unless an extension is granted, a determination will be issued within 30 days after the hearing record is closed. Director review and reconsideration. An appeal determination is a final administrative action on the issue, unless a director review is requested. If a director review is not requested, a hearing officer's determination is a final determination of the division and is reviewable and enforceable in any U.S. district court or competent jurisdiction as specified by law. A party may request reconsideration of a director review determination if the party specified that the determination contains on its face a material error or of fact or a detailed explanation of how it is contrary to statute or regulations, which would justify reversal or modification of the determination. Reconsideration may be requested by appellant or the agency within 10 days of the receipt of the director review determination. NAD will notify the parties of whether the request for reconsideration meets the criteria. If the criteria are met, it will provide a copy of the request for reconsideration to other parties who may file a response to the request. Responses must be filed with the director within 5 days of the receipt of notice from the director. Final determination. Hearing officer's appeal determination is administratively final unless a party, an appellant, the agency, or a third party, but not an interested party, files a request for director review on a timely basis. The appellant has 30 calendar days from the receipt of the determination within which to request the director review. The director of NAD is housed within the headquarters. This would be if you appeal and you don't like the decision of your hearing officer or administrative judge, you can then appeal for director review. Director review, an agency has 15 business days to make a request. When a final determination finds that an agency erred in an adverse decision, the head of the agency shall implement the determination within 30 days of receiving notice of the final determination. So if you do not request a director review and your appeal makes a determination requesting an agency modify or change whatever you've requested in your appeal, the agency has 30 days after receiving the final determination to make those changes. If you request a director review, then it's 30 days after the director reviews determination. NAD has no authority to enforce implementation of its determinations. The final determinations are enforceable by a participant in any U.S. district court or competent jurisdiction. So if the agency then receives the final determination and they do not act upon that final determination, you don't go back to NAD. NAD has no authority to enforce that determination upon the agency. You can then seek reprimand within the U.S. court through our whatever jurisdiction that you might be in. And that is 7 U.S.C. Section 6999. Final determination. Next slide. Equal Access to Justice Act. The purpose of the Equal Access to Justice Act provides attorney's fees and other expenses to eligible participants who prevail unless the position of the USDA was substantially justified or special circumstances make an award unjust, as specified in 7 CFR Section 1.181. A NAD adjudicative officer appointed by the director will issue an initial determination on an application for the Equal Access to Justice Act fees and expenses. A number of the final pages in the guidebook are related to this act and those that can utilize this act. An adjudicative officer is an administrative law judge or other person assigned to conduct the proceeding. If it is determined that an applicant prevailed in the appeal, the applicant may receive an award of fees and expenses unless the agency's position was substantially justified. To obtain payment of an award, a successful applicant shall submit to the head of the appropriate agency a copy of their request for the Equal Access to Justice Act designation granting the award, and they also must present a statement that the applicant will not seek court review of the decision. The agency is to pay the award within 60 days. There are various criteria to participate in the Equal Access to Justice Act. 3 of those qualifiers are your net worth test. An individual cannot make more than $2 million annually. Businesses cannot make more than 7 million, or corporations, and you can have no more than 500 employees in order to utilize the Equal Access to Justice Act. Here are the resources. Where to file an appeal. This is NAD's website. Within that website, you'll find the hearing guide. You can also search for NAD decisions. I've also linked NAD's organizational chart. If you are looking for an advocate or somebody to assist you, you can utilize the Indian Agriculture Council technicians, and I've added a link to their website as well. Now to move on to some question and answers and a discussion as it relates to the Farm Service Agency finances and determinations made regarding applications for loans or loan servicing. Many of the cases that the Farm Service Agency receives, or NAD receives, regarding the Farm Service Agency as it relates to applications for loans or loan servicing are related to, in the application process, either you've been denied a loan or you've been denied servicing of a current loan that you have. These instances can be that, examples include that you didn't receive proper notice of your options for loan servicing, or that you presented various income documents and perhaps the office that you applied to or the committee that you were going through didn't read carefully through these documents, therefore determining that you were ineligible. Another instance is that they will tell you that you can, because of your credit score or the region that you're within, you are eligible to go to a private bank or other entity to receive this funding. Those are other instances where individuals have appealed to NAD saying, although on paper it looks like I should be able to, or my net worth and credit score indicate that I should be able to qualify for loans. I cannot. This is especially an issue for Native Americans that are applying for loans, because often conventional banks, as soon as they see that you are utilizing restricted land, trust land, lease land through the tribe, allotted land, they will automatically tell you that you cannot apply for loans within their institution. So FSA or getting a guarantee loan from the Farm Service Agency is your only option. So some recent appeals that have occurred within the National Appeals Division in the last 6 months are cases where an individual either didn't get proper servicing, they were not provided proper notice, or they were not provided a continuation of operating loan because they were defaulted on a federal loan. You cannot default on any type of federal loan to qualify for a number of FSA loans or loan servicing. Many of the recent cases in the last 6 months are in regards to the Conservation Stewardship Program. That is an NRCS program, but FSA, the Farm Service Agency, and the Natural Resource Conservation Program work together to administer that program. NRCS provides technical relief, and FSA has to provide background and yield information. Together, they decide the needs, conservation needs and point processes for determining applicants in various regions. Those have been, CSP is the abbreviation for that program. That has been a number of the most recent appeals to NAD. There's also been issues of operating loans, individuals that have filed NAD complaints in relation to their operating loan. For many Native Americans, the fact that they can't even obtain an operating loan has been significant over the years. And in addition, they cannot provide that they are the majority shareholder or designated officer that can make decisions for that property, because it is, again, either fractionated or they are an heir. So providing those types of proper documentations, making sure that your local office, both NRCS and FSA, are aware of the type of land that you're utilizing. NRCS and FSA have in the past been briefed on working with trust land or restricted land. Unfortunately, in many areas, they have one person that knows how to process those applications, and they might be covering a region of multiple states. And timeliness is important when you're working with land and crops, or as it relates to disaster assistance. So making sure ahead of time that whoever you're working with has the knowledge to work with the type of land that you're utilizing will lessen your chances of having to file a NAD appeal. Other instances of where individuals, Native Americans particularly, have had to file appeals, one of the basic questions becomes, is this a discrimination issue? Is this a NAD appeal? Determining between those two is very important. If you do not know, you can apply to both just to be safe, but they go to two different offices. When you're applying for a discrimination complaint, when you are being discriminated against for the various reasons discussed in our dismissal slide, your race, religion, being a female, all of those criteria, then you file a discrimination complaint with the Office of the Assistant Secretary for Civil Rights within USDA. If it's a matter of your office isn't processing your application because of their failure to recognize a rule or regulation or an oversight on their behalf, then you file a NAD appeal. Okay, questions?
All right, thank you, Toni. So I just want to remind our audience that if you have any questions about the presentation, you can raise your hand by using your control panel. If you raise your hand, then I will unmute you and you can ask your question, or you can type in your question to the questions box and I will just read it out loud and Toni will answer your question. I'm not seeing any questions. So we'll wrap up today's webinar. The contact information is on the screen in front of you. Toni's contact information is there. I'd also encourage anyone interested in this presentation or any of the other presentations that we've had in this series to go to our website that's on the screen, indigenousfoodandag.com/FSA. If you go to that webpage, you'll be able to see all of our you'll see videos of all of the webinars that have been done in this series. And it looks like we do have a question. Okay, Toni, you ready for a question?
Yes.
The question is, how does the FSA County Committee fit in?
So an FSA county committee has authority to make determinations on certain types of applications. So if you're in a region and you want to apply for, I talked about CSP earlier, a county committee helps make those determinations. So if they are the determinations on who's going to get part of that CSP funding, whose land will be enrolled into those areas, and they also help make determinations, I believe, on the productivity of your individual land. I can't think of the term, but nonetheless, the county committee has a lot of authority, and you can also find on the web a county committee guide that was published, I think, in 2011 or 2012. There was a new directive that was sent with that basically says eligibility for certain areas. So a lot of these county committees were historically non-representative of minorities and females, and the secretary at the time decided that he would do a review of all these county committees and make sure that minorities and females were included in these county committees because of the amount of authority that they have in making different types of determinations in areas and disaster assistance, etc. And also in that determination, I have personally told tribes, if your tribe utilizes USDA programs or services, it doesn't have to be an FSA program, could be an RD program, whatever it might be, then you are eligible to vote in a county committee. And the county committees, I think it's in September when you get the notice for elections that year, and please apply to sit on your county committee because they do have authority. And because they have authority to make these decisions, when you get an adverse decision and it's from your local office, they will note the county committee's decision in their overall final determination. And so when you appeal, you can appeal. You have to appeal to, or you have to bring notice to that county committee, and they can then call a special meeting to review your documents again. You can go before that county committee to present your issues, and then they will then make another determination on whatever you have appealed. And if they, again, deny what you have requested, then your final appeal goes to your NAD regional office, or you can then, after you've exhausted your NAD regional hearing, you can request a director review. But again, they are a player in the initial application and in your initial denial. So it's just one of those offices that you have to box check in the exhaustive remedies. in administrative law, generally, you have to exhaust remedies, and that is just one of those remedies that you exhaust in the decision-making authority or chain of command.
Okay, thank you, Toni. We have one other question, and the question is mediation ADR required before NAD appeal?
In some areas, it is required. It depends on what program specifically you are appealing. And I don't have an exhaustive list of each of those, but your office, when you get a letter, it will notify you that that is a remedy that you have to pursue. But again, it will come from your regional office, and if it's not a letter saying that you have an adverse decision, instead it's a failure to ask, then you contact your regional NAD office, and I think that was slide 4, your regional offices, or just Google it, and you can ask them if that is something that you are required to do. But it depends on what you're appealing. If it's outside of NAD's jurisdiction, if it's a discrimination case, if it's something that they don't have the authority to rule on, then it goes straight to whatever office that your NAD regional office will direct you to.
All right. Thank you very much, Toni. Last call for questions. And I'm not seeing any, so we will go ahead and conclude today's webinar. Thank you, everyone, for participating. And again, I encourage you to visit our website that is shown on the screen for more information. And we look forward to checking in with you next time. Thanks a lot.